the city of LA right now, tonight, is going to be voting on keeping that rent freeze in place, which will be more than 4 years. They want to keep that rent increase, the freeze on rent increases in place until July of 2024. That will be greater than 4 years that landlords in the city of LA went without a rent increase. And I know the city has been telling everybody, oh, we're going to give you a 7% increase to make up. No, they're not.
Hi, this is Chris German, and welcome back to the Apartment Dealer Show. Well, this is episode 3 of our 3-part series, all the recent bills that were signed into law by the governor. What do they mean? We need the details. If you did not watch part 1 or part 2, I'd say watch those videos first for this video to make sense, as it's a continuation of that discussion of the outlining of what are these new laws, what you need to know as a landlord. But here we go. We're going to now get the final wrap up and Mike's thoughts leading into 2024 when it comes to the legalities of owning multifamily properties. Let's go to the rest of that interview now.
Let's talk about Senate Bill 71. This basically increases the small claims cases. The small claims amounts that people can file. The reason that impacts landlords is, one, you've got COVID rental debt that people still haven't paid, and that's all supposed to be going through small claims court. So that increases that amount. But also you've got tenants who move out and damage properties, or security deposits aren't enough to cover the damage that was there. And so the amount, and I apologize, I forgot to write the amount down, but the jurisdictional amount of small claims has increased. Let me tell you why that's almost a false sense of security. They also, last year, you'll remember, Chris, Governor Newsom signed into law a new law that basically reworked the structure, the metrics used for wage garnishments. So as a landlord, you could go and whether you got a judgment in eviction court or you went to small claims court and got a judgment, you could pursue that through a wage garnishment if you could find the person after they moved and then figure out where they're working. And in 2022 rather, Newsom signed that law that reworked the metric used. And so, for example, in Los Angeles, this is a rough number, but essentially to use a wage garnishment in LA, that tenant has to make approximately north of $40 an hour. And there's not a lot of tenants making north of $40 an hour.
Right.
You wouldn't be evicting them if they were, in most cases. So this increase in the small claims jurisdictional limit is, it's somewhat limited as a positive to landlords. That brings us on to Senate Bill 267. And this one, it goes back to the theme I was talking about before about limiting landlords' abilities to screen tenants. They just basically want to force you to accept anybody that walks through the door. So this one now says that if you screen a tenant, you use something that you find in their credit report as a negative in your screening process, you have to allow them the ability to provide alternate evidence of financial responsibility and the ability to pay. So what does that mean? We have no idea yet. What would they use as alternate evidence, right? You can't use a credit report. I suspect what you're going to see right off the bat is, well, I want to use my landlord. I've lived there for 3 years and I paid my rent on time. So here's a letter from my landlord that says that. What's the problem with that? Their landlord is probably their brother, right? They've been evicted multiple times in that 3-year period. And that letter you just got was signed by their brother, who's their landlord for the purpose.
Or even from a landlord who's happy to see them go, right? Okay, I'll pass my problem on to somebody else.
I don't know too many landlords that would affirmatively put their name on a letter saying, yeah, they paid their rent on time. They'll do a neutral reference to get rid of them in an eviction all day long. Yeah, they've lived here between these dates, and that's all I can say. But I don't know too many landlords that are going to affirmatively say, yeah, they're my tenant for the last 3 years and they paid their rent on time, knowing that that's a lie. But the problem is it's a limitation on the screening. And there is a movement going on, again, talking about trends, to get rid of the credit reporting system. And if you read anything about it, it's actually, there is some validity to it, the thoughts that underlie this movement to get rid of it. but not enough to just trash it. And the White House has even come out and said, "Hey, look, we don't think the current credit reporting system it works. It's discriminatory, and what we would call disparate impact discrimination, because larger numbers of protected categories have bad credit, because larger numbers of protected categories get evicted, and larger numbers of protected categories get arrested, and larger numbers of protected categories have multiple children, and larger numbers of protected categories. The list is endless. So because those protected categories have larger numbers of people that do all of these things or are affected by all of these things, a policy that says, hey, we rely on credit and a good credit history to accept you as a tenant has a disparate impact. In other words, it negatively impacts those protected categories. And so we have to get rid of this credit reporting system is the philosophy.
So my understanding then is, so with this here now, credit comes into question. The criminal background cannot be used as well, correct? That you can't use one's criminal history to deny a tenant. Is that correct?
That is not entirely correct. There's a whole hoop you have to jump through now. So the ban the box is what we call it, and that lost again in Sacramento. That has probably been a bill for the last, 10 years. And it never passes, but we are moving it. But a local municipality can pass something along those lines. And the way it typically works is you're not allowed to ask about criminal history on the first go around. In other words, when they submit their application, right? You can ask about it if you're considering giving them the apartment. And then if you're in a jurisdiction that does have it on the application and allows it, and they say, yes, I have a criminal history, then you have to go into that criminal history and do an analysis of the history. So in other words, what was the conviction? How long ago? Does that specific crime potentially impact the neighboring tenants at the building? And does it impact the building itself? So it's very funny. I just had a conversation with one of the directors at Fair Housing just a couple of days ago about this very topic. We were just trying to clarify exactly, okay, what does she think? What do I think? How do I think it's interpreted? And she said, initially her position was, you can only deny them if that crime puts the other neighboring tenants or the management at risk of harm. And I said, well, what about white collar crime? Nope, that wouldn't work because it's not physical harm. Okay, well, what about identity theft, right? So they've been convicted of identity theft, and you're now putting them right next to a local mailbox that's got, 20 mailboxes next to dumpsters where people throw their trash out. And she said, oh, I'd never thought of that. That's a possibility. I said, okay, what about arson? That's a crime against property, and that's not a crime against people. Oh, I'd never thought of that either. Yeah, I could see how that would potentially put them at harm if the building burns down. Obviously, that impacts potentially impacts their health and safety. So, Fair Housing doesn't even have a really concrete set of what crimes you can and can't deny for. All they have is some guidelines that say, hey, you don't want to ask about it right up front. If they check the box, you've got to look at their history. And were they in prison? Are they rehabilitated? Did you ever see Shawshank Redemption?
Yeah.
Remember where the parole board's asking him, are you rehabilitated?
Right.
He's like, I have no idea what that means. And they say, great, paroled. Yeah. So anyway, that's the direction we're heading with this trend is, again, limit a landlord's ability to really weed out the problematic tenants and want to bring in the qualified tenants. So anyway, so the big one that I'm sure everybody, hang on a second, let me just we talked about 267. The big one I'm sure you want to hear about is Senate Bill 567. And I'm sure your members want to hear about that as well. And this is an amendment to the Tenant Protection Act of 2019, which is also known as AB 1482. And the amendments on this are pretty significant. They are less than what was originally wanted. So I won't call this a complete victory. It's a very small victory, but initially what they wanted was incredibly onerous, and all these legislative bodies and entities were able to get a lot of it carved out. But the two amendments that are important to understand here are owner-occupied evictions and just cause evictions for a substantial remodel. And so the owner occupied the requirements to terminate a tenancy for you or a family member to occupy the unit have increased. Now the name of the potential occupier has to be on the notice. There's different notice requirements. But the more important one I'm imagining for your members is the substantial remodel. And the substantial remodel was modified in a way that emulates a lot of the local jurisdictions requirements that are already in place. For example, it used to be pretty straightforward that if you wanted to do a substantial remodel, all you had to do was give the tenant a 60-day notice, waive their last month's rent, and put the amount of rent that was waived in the 60-day notice. And as long as the remodel was going to touch one of the major systems of the unit, that was all you needed to do. And that has changed significantly now. The requirements are that not only does it have to touch one of the significant systems of the unit, but you have to pull all of the permits necessary. You have to describe in the notice why it is that the tenant can't remain in place safely during the construction. You have to outline what exactly is going to take place and why that requires the tenant to be out of possession for more than 30 days. And so it's a significantly more burdensome requirement on the landlords now. And what I think is going to happen is where landlords are going to get tripped up on this is the pulling of all the permits. It's all of the necessary permits. So it's going to be hard to argue, for example, that, I want to remodel the bathroom. The plumbing is bad. And so we're going to remodel the bathroom and that requires a permit. Okay, no problem. But why would that require a tenant to be, why can't you do that safely, especially if there's a second bathroom in the unit? And why would a bathroom require the tenant to be out of the unit for more than 30 days? Now there's answers, legitimate answers to both of those. We all know that getting contractors to complete something, even a bathroom in 30 days is next to impossible. Mm-hmm. But you've got to go through that and it opens the door for a tenant to challenge it. They can come into court and it's going to be, the trier of fact. You don't have a right to evict me because this is nonsense in your notice. It shouldn't take 30 days. And especially if they demand a jury trial, you've got a juror, 12 people sitting on there that have very likely never done a remodel, never pulled a permit in their life. They don't understand the system. And it may seem like this landlord is just trying to get rid of this tenant and that it's all sham. Now, where I don't think they'll have problems, that maybe some administrative problems at lining it all up so it works effectively, is if you really are going to do a real remodel. For example, you and I have some mutual friends and clients that had to tear out the entire plumbing of I think it was a 1940s building up in Pasadena. And it was a legitimate, hey, we got to get everybody out of these units because the plumbing is galvanized. It's literally breaking in every single unit. And we've got to tear these walls out. That, I think you're not going to have a problem with a project like that. So as long as it's a legitimate, remodel that's going to legitimately require a lot of permits, or maybe not a lot, but a significant amount of work to a significant system in the unit, I still think that will be able to be pushed through as long as all of the permits are pulled and they have to be attached to the notice now as well. So that's where it's going to administratively.
The permits have to be attached to the notice?
Yes.
Wow.
Yeah. So it's not simply pulling up. And I'm seeing more and more just cause ordinances pop up with that requirement. But, so maybe you do it in phases, right? Phase one, we're going to do the plumbing. So right now I need everybody out just to do the plumbing and I pull all the plumbing permits and attach them to that notice. Maybe when I get in there, I'm going to modify that program. I might do more work later, but for right now, all I'm doing is the plumbing. And that's a legitimate basis to get rid of the tenants. So this is what, going back to what we were talking about earlier about shaking the mom and pops out of the industry. The larger companies will be able to facilitate this stuff. They've got the people on board. They're already full-time staff members. They're going to go ahead and line this all up. And they're going to get it taken care of. But it's the mom and pops that are going to have the real problems facilitating this stuff, especially the mom and pops who both have full-time jobs and, are trying to run a full-time job in a household and a small building and navigate this permit process and get everything lined up so that the timing is all correct. And it's going to be challenging, to say the least. Something just popped into my mind that is important for your members to know. That Senate Bill 567, That does not go into effect until April 1st of 2024. That's the rent control, the just cause one, and the substantial remodel and the owner occupancy.
Everyone's getting their 60-day notices.
Exactly. I was just going to say that. If you've got clients that are even thinking about doing substantial remodels, now is the time to do it. Get those notices out, get it done while you don't need the permits. You've got, like I said, that law goes into effect April 1st. Now, remember what happened in 2019. In 2019, we had statewide rent control on the ballot. In fact, it was the Tenant Protection Act that was on the ballot. And because it wasn't going into effect right away, do you remember what happened with all the cities and the municipalities? They all started
emergency orders in place.
They all started enacting urgency orders. And so, like I said, for your members who are even thinking about substantial remodels, do it now before these cities start implementing these urgency prohibitions.
We will get that word out, because that's one of the winning game plans that we've shared with our clients, individuals who attend our educational events, is that this is one strategy to leapfrog over rent control, the limits of rent control, to bring your rents to market and above market. And once that's gone, I'm a pretty clever guy, but I don't know if I'll be able to come up with anything else to get us around these restrictions, especially as they get tougher and tougher under rent control. So, and I know our time is ending here. Mike, you've been very gracious with your time. Do you think we've covered the major bills that one would need to be aware of? Is there
just one more I was going to add? That's Senate Bill 712, and that basically prohibits landlords from preventing tenants from owning or storing or recharging the micro mobility devices, they're called. We're talking about those little scooters and those little bikes, e-bikes, e-scooters, stuff like that. You can't tell a tenant that they can't have it, and you can't tell a tenant that they can't charge it, and they can store it on your property. So this is one of those camel's nose under the tent situations, right? A decade ago, you couldn't tell them that they couldn't have a charger, but you didn't have to pay for it, and they did have to hire a licensed contractor to install it. Now things are changing. What we're going to start seeing laws passed that say, yeah, the landlord has to pay for it. It's the landlord's responsibility to make sure it's there and done correctly. And no, you can't say, no, my building is too old and I've got, for example, aluminum wiring, and because of the costs involved in upgrading the building, I don't want to do it. You're not going. Currently, you can say that, but under this law and how I see this law progressing, you won't be able to say that in the next 5 to 10 years.
Well, year over year, especially over the last 4 or 5 years, it's only gotten that much more difficult to be a landlord. And so I know at our event, you commented that one has to really ponder, are they prepared to continue to manage and own under these restrictions? Can they stomach, potentially what's coming down the road?
Right. It's funny that you would bring that up. Two people at a recent seminar came up to me and said, hey, at Chris German's luncheon, you said there are people in this room that shouldn't be landlords. What did you mean by that? And it seemed like they took that personally, like I was insulting them. And I'm not. I'm simply saying, as you just worded it, you have to ask yourself, is this for me? Is it, especially anywhere in LA? And do I really, not only can I stomach it, do I want to stomach this anymore? Can I 1031 into something else that makes more sense? In fact, I think you and I you were supposed to talk to a mutual client of ours the other day, she's got that building that she wants to sell.
Mm-hmm.
She can't stomach it anymore. She's so tired of this stuff that she's like, get me out of this stuff. And she's looking to move into a triple net.
Well, so one has to consider, peace of mind, quality of life, all these things now are being impacted by, signing up to own multifamily properties. And again, for clarity, it's not like I'm selling, my wife and I are selling all the buildings we own, but we've made a decision, at least as the recording of this video, so far, okay, we don't like this, but, I'm at a position where I have the network of professionals like you or Steven Spear on the other side of real estate law and others that can assist me in this way. Financially, we're able to weather some of this stuff. And so, yes, for the moment, we can stomach it. But there's, for many others, they just won't be able to. and it'll be to their detriment as things only progress and as things only get worse.
It's a question of it's no longer tolerable. That's one level of looking at it. I just can't tolerate it anymore. Or what I think will happen sooner to more people is it just doesn't make sense. You and I were talking before we started this recording. I brought up the fact that the city of LA right now, tonight, is going to be voting on keeping that rent freeze in place, which will be more than 4 years. They want to keep that rent increase, the freeze on rent increases in place until July of 2024. That will be greater than 4 years that landlords in the city of LA went without a rent increase. And I know the city has been telling everybody, oh, we're going to give you a 7% increase to make up. No, they're not. The reason they're voting to freeze that increase is so that they can rework the metrics to give you less than 3%. So it doesn't make sense anymore for a lot of people to be hanging on to these buildings. So it, unless you're a much larger player who's got those economies of scale and you have your systems in place, you know how to go in and navigate these buildings and navigate the numbers so that they do make sense. But yeah, it's a challenging environment to say the least for your rent.
And we're glad that you're here to be lockstep with us to track these laws as they come to pass. I'm sure come next year, especially with the new rent control bill that's going to be on the ballot for 2024 and see what direction that goes. Well, there'll be much to speak about, especially like you said, as some of these bills that you've outlined today, there's not complete clarity. So how does that play out as they begin to get challenged in the courts? Well, with that, Mike, again, I want to say thank you. I know that the landlords are very grateful to you that you openly share this information to empower them. And I appreciate your friendship here with the apartment dealer. And we look forward to having you back.
Thank you very much, Chris. I appreciate the time to be here. Thanks.
All right, sir. Take care.
All right.
Now, if you're new to our channel, I invite you, scroll through the videos here. There's hundreds of hours of free educational content where either I share what is taking place in the market, some winning strategies when it comes to multifamily properties here in California, or where I've interviewed the pinnacles of the multifamily industry to inform you in each of their professions, whether it's the legalities of owning multifamily property, the taxation of multifamily property, exit strategies for multifamily property, fix and flip, all the rest. The videos are here. I invite you, peruse around this video here. If you've enjoyed the content, please give us a like, share a comment below. Let's start to interact together. I'd be curious on your feedback. What are you experiencing as a landlord? Let's get that discussion going within the community. And as we head into the end of this year, there's going to be more content that we'll be sharing, more updates, and especially as we head into the new year for 2024. Chris German from The Apartment Dealer, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.